If you're a high-skilled professional researching U.S. immigration, you have probably come across dozens of visa categories: H-1B, O-1, EB-1A, EB-2NIW, L-1, E-2. And if you're like most people, you're not entirely sure which ones actually apply to you or how they connect to each other. And that confusion is not just frustrating, it is actually one of the most common reasons people pursue the wrong visa at the wrong time, which can lead to wasted time, wasted money, and in some cases, real damage to their immigration record. In this video, I'm going to walk you through every major U.S. high-skill visa category available in 2026. I'll explain what each one is, who it is designed for, and when it makes strategic sense. By the end, you'll have a clear picture of the entire landscape so you can start making informed decisions about your own path. Many high-skilled professionals begin their U.S. immigration journey not with the work visa, but with a student or exchange visa. This is where a large number of future EB-1A and NIW applicants first enter the system. We have the F-1 visa, the primary student visa for international students pursuing academic programs in the U.S. F-1 visa holders can obtain work authorization through optional practical training, or OPT. If the student is in a STEM field, they can get a STEM OPT extension up to 3 years of total work authorization. This period is often when professionals begin building the evidence and track record that will later support a green card petition. Next, we have the J-1 visa for research scholars, exchange visitors, professors, doctors, and academics in exchange programs. These are inherently high-skill visas, but there's an important caveat. Some J-1 holders are subject to a 2-year home residency requirement, which can affect future visa options. This needs to be evaluated early, and it can significantly limit what comes next if the person is not aware of it. These visas get people into the United States, but they are temporary. The next question almost every professional faces is, how do I stay and work legally? The most common next step for high-skilled professionals is an employer-sponsored work visa. These are visas where U.S. employer petitions on the professional's behalf. First up is the H-1B visa for specialty occupations. This is the most well-known employer-sponsored work visa. It is for specialty occupations requiring a minimum of a bachelor's degree. It requires an employer sponsorship subject to an annual lottery tied to the sponsoring employer. If the employment relationship ends, the visa status is affected. This is one of the primary reasons many professionals eventually explore employer-independent options. Next, we have the L-1A visa, multinational executives and managers. For executives or managers being transferred from an international office to a U.S. office within the same multinational company, it requires an existing multinational employer relationship. The L-1B visa, known as Specialized Knowledge Visa, is for employees with specialized knowledge being transferred from abroad to a U.S. office. It has the same multinational employer requirement as an L-1A. Next up is the TN visa, specifically for Canadian and Mexican nationals. There's a specific list of qualifying professions. Not every occupation qualifies for a TN. Next up, the E-2 visa, or the Treaty Investor visa. This is for entrepreneurs and investors from treaty countries investing substantial capital in a U.S. business. It is a non-immigrant visa and does not directly lead to a green card. It can be part of a broader immigration strategy for entrepreneurs. All of these visas are either temporary, employer-dependent, or both. For many high-skilled professionals, the ultimate goal is permanent residency, a green card, without being tied to a single employer. That is where employment-based green card categories come in. The EB-1 is the highest preference category for employment-based green cards. First up is the EB-1A for extraordinary ability. It is a self-petitioning green card. No employer sponsorship required. It's for individuals who can demonstrate extraordinary ability in sciences, arts, education, business, or athletics. USCIS evaluates whether the applicant meets at least 3 of the 10 regulatory criteria and demonstrates sustained national or international acclaim. Extraordinary ability does not necessarily mean fame. Many successful cases involve professionals working behind the scenes whose impact is undeniable. Next up, we have the EB-1B for outstanding professors and researchers. Requires international recognition for outstanding achievements in an academic field. Unlike the EB-1A, it does require an employer sponsor, typically a university or research institution. Lastly, we have the EB-1C for multinational managers and executives. This is the green card equivalent of the L-1A. Employer-sponsored, requires a qualifying multinational relationship. There's a key distinction here. EB-1A allows self-petitioning. EB-1B and EB-1C require employer sponsorship. For professionals who want independence from a single employer in their green card process, the EB-1A is the relevant category. The EB-2 is the second preference category, and it contains one of the most strategically important options for high-skilled professionals. First up, we have EB-2, the standard option. This is for professionals with an advanced degree, such as a master's or higher, or a bachelor's degree plus 5 years of progressive experience. In its standard form, it requires employer sponsorship and a labor certification through the PERM process. But then we have the EB-2 National Interest Waiver, which is one of my favorites. The EB-2 NIW waives the requirement for employer sponsorship and labor certification. It is for professionals whose work is so important to the United States that it warrants bypassing the traditional process. USCIS evaluates whether the proposed endeavor has substantial merit and national importance, whether the applicant is well positioned to advance it, and whether on balance it is beneficial to waive the requirements. The NIW is not about a job title or a degree. It is about how the applicant's specific proposed endeavor benefits the United States broadly. Framing and legal strategy matter enormously in these cases. Next up, the O-1 visa, which is a strategic temporary option. The O-1 sits in a unique position. It is a temporary visa built on extraordinary ability standard. We have the O-1A for individuals with extraordinary ability in sciences, business, education, or athletics. It is a non-immigrant, meaning temporary visa, not a green card. The evidentiary standard is similar to EB-1A, but evaluated differently. Next up, we have O-1B, the arts and entertainment counterpart, distinct evidentiary standards. Many professionals use the O-1 strategically as a bridge, maintaining legal status and work authorization while building towards an EB-1A or an NIW green card petition, as an alternative when not selected in the H-1B lottery. And even for entrepreneurs who need to work in the United States on their own venture without direct employer sponsorship. The right visa is never about what worked for a friend or a colleague. It is about the individual's profile, evidence, timeline, and goals. Key questions every high-skilled professional should ask. Where am I in my career and immigration journey? Do I need an employer sponsorship or can I self-petition? Is my immediate goal temporary work authorization or permanent residency? Is my evidence strong enough to file now, or would I benefit from additional preparation? And many professionals combine strategies, maintaining H-1B or O-1 status while preparing an EB-1A or NIW petition. Choosing the wrong category or filing at the wrong time can create problems on the record that are sometimes difficult to correct later. Strategic planning at the beginning prevents damage down the line. If you're unsure which visa category is the right fit for your background and your goals, you can request a free case evaluation using the link below. My team and I will review your credentials, your current immigration status, and your long-term goals to help you determine which path makes the most strategic sense for your situation. Now that you understand the full landscape of U.S. high-skilled visas, one of the most important things to understand is that Qualifying for a visa category on paper does not automatically mean your case will be approved. This is especially true for discretionary categories like the EB-2 National Interest Waiver. Many applicants believe that if they have an advanced degree, strong experience, and work in an important field, they should qualify for the NIW. But that is not actually how the process works. Part of the EB-2 NIW analysis is objective, and another part of it is discretionary. And misunderstanding where that discretion applies is one of the biggest reasons people approach their cases with the wrong strategy from the beginning. So in my next video, I explain how USCIS discretion actually works in EB-2 NIW frameworks, what parts of the process are black and white, and why understanding this distinction can make a major difference in how you prepare your case.